Yes, excellent. Welcome also from my side, and thank you very much for joining this session. I'm obviously very honored and pleased that you keep up with your interest in European digital markets regulation. Many things remain the same, the issues remain the same we are talking about, but obviously things develop over time. Also personally, things develop, as you can see here on this slide. If you had contact with me before, you know that I was usually representing here the Monopolies Commission. Since September last year, I have been a professor at Frankfurt School of Finance and Management, there for public law, regulatory law, and comparative law. However, obviously, I still keep my interest in digital markets regulation. Also, I keep the ties to the Monopolies Commission, and I will certainly build also on the experiences and the positions the Monopolies Commission developed in today's presentation. So, what are we actually going to cover? You were very kind to submit questions for our discussion here, which I then embedded in this presentation. I will do a structured presentation where I go through with you through the Digital Markets Act systematically, and I will address your questions on the way, basically, where they fit into the structure. So let's start, and I will skip the intro slides about how we basically came to the DMA. And for our discussion now, I assume that you are aware basically of the key problem we are facing with digital ecosystems. Let me just point out one or two points that are helpful for the understanding of the DMA as it evolved and goes directly to the DMA. So the main understanding of digital ecosystems from a competition law perspective nowadays is, in Europe at least, that digital ecosystems pose novel issues to competition law and cannot really be tackled with existing competition law. Why is this? Well, because the competition issues associated with digital ecosystems are not necessarily linked to relevant markets, where we could apply, for example, Article 102 TFEU or Article 19 of the AMA, but they are cross-market issues, where you basically have to consider this cross-market phenomenon to correctly handle these issues. And this finding basically was made when it was understood that digital ecosystems not just operate proceeding from individual platform markets, but that they expand their reach by usually looking at user preferences, therefore analyzing and collecting and analyzing data on user preferences, and then building up additional services that complement and are compatible with the original platform service. So the DMA is then a very strange animal, because the DMA does not say this. Other than Article 102, for example, about abuse of a dominant position, which says explicitly, well, this is about dominant positions and their abuse, the DMA has taken a very formal approach. And it also, which makes things additionally complicated, says, well, it's not about competition. This statute is about contestability and fairness. Contestability and fairness, why? Well, if we consider what an ecosystem is, we know that it is a structure that basically is very is operating in an area where you have very high entry barriers. It proceeds with its development from a situation where one platform market has tipped in favor of the digital ecosystem operator. So already there, very strong, very high entry barriers. You compete for the markets to displace this ecosystem operator, which is barely possible. So contestability is therefore something that needs to be ensured to open these markets up again to competition. In fairness, well, if the market is very close, if there is just one company left, then it's easy to exploit the bilateral relationship between the platform and the platform users, both commercial users and end users, right? Because they have no alternatives to go to. That is what behind contestability and fairness. It is related to competition, but it's ecosystem specific, we could say. So the objectives are special, but then also the formal approach that was taken to basically evade discussions on substance with the digital ecosystem operators, because apart from competition law and substance not working very well to grapple with this, to tackle this cross-market phenomenon, we also have a problem of competition law procedures take very long, and this should be avoided by introducing a new type of regulation formal approach. Therefore, which starts with the formal designation of gatekeepers. Those are the legal addressees of the new statute, so the digital ecosystem operators. And these formally designated gatekeepers are then submitted to an ex-ante regulation, which includes conduct and transparency obligations. These obligations apply across markets, so that mirrors the ecosystem phenomenon. The situation on individual markets is irrelevant, but also that means that any pro-competitive justification for certain conduct, which may exist on certain markets, this pro-competitive justification is irrelevant. Last point, which generally, what do you say? But generally marks, the DMA is the concentration of supervision with the European Commission, different for the European system from the original competition law system, where you have a two-tiered structure with the European Commission on top and the national competition agencies below that. Here we have a concentrated supervision to reflect basically also the cross-border nature of ecosystem operations in Europe, and also to render the enforcement more effective. So let's dive a bit deeper now and look first at the objectives of the DMA and the remaining element of competition law. A number of questions were posed to me regarding these two issues. So first question was basically whether the DMA should be considered a new global standard, whether it was meant to be, intended to be a new global standard, or whether it should be considered rather regulation specifically for the EU internal market, and whether also the Commission basically does not want to reach any further. So my answer to that question is that the second option appears closer to reality. That is for various reasons, three reasons in particular. First, the impact assessment accompanying the proposal of this regulation shows what the European Commission had in mind. And that was actually quite open and quite frank in its formulations. And there were two issues that the Commission had in mind. One issue was that the Commission actually considers the core markets of those digital ecosystem operators, so the core platform markets of these operators, to be failed markets nowadays, simply because it is not conceivable, at least in the near future, that anyone will come in to displace, for example, Google in general online search or Amazon in general online trade, or the other ecosystem operators, you name them. The second issue that the Commission considered, wait a second, and just as a personal comment here, we also have an important argument to say that this is actually not competition law, because competition law assumes there to be functioning markets. The competition law is not there for failed markets. Even though market power can result in market failure, obviously, but competition law still assumes that even a dominant company can be replaced by someone else. If that is not the case anymore, we gradually leave the ambit of competition law and enter more into the ambit of regulation, right? For example, also for postal services or other services, we would say, well, actually, if we have a natural monopoly, right, well, we can apply competition law, but we need basically need also regulation to tackle the market failure. So this is one important point, was one important point for the Commission to introduce the DMA. The other point was market fragmentation, which risked to develop in Europe already by means of national regulation in Germany, famous or notorious Section 19A, which was also specifically introduced to handle issues of digital ecosystems. Section 19A is still part of competition law, but it is running counter basically to having a single market. Therefore, the DMA was considered necessary. Main drivers in practice were internal. The Commission was under huge pressure, or has been under huge pressure, to do something about Google, Facebook, and so on, where it was considered that enforcement was actually ineffective. But obviously, there is something the Commission did not put into the forefront in its impact assessment. And there may indeed be an industrial policy interest, but that interest is certainly not that strong, because if it was openly pursued, basically, then the Commission would advocate a statute that is discriminatory, whereas in general, the Commission and all the other EU institutions build their trust, also within Europe, on the fact that the law is applied in a deliberated fashion without discriminating anyone. So basically, they may be interested personally, the Commission officials, in doing something to boost the European digital economy, but they will be careful to not have this influence on their decisions, or at least not allow anyone to trace that back. So basically, the Digital Markets Act should also not be understood, even though people may be happy about the European digital economy thriving. The Digital Markets Act should not be understood as a statute that is directed specifically against anyone, and that is there to boost the European economy. That would be too far-reaching. So that's the first question. Second question is whether this is about competition, basically, or unfair business practices. And I already provided the answer regarding the general structure of the DMA, where I explained the objectives to you. However, here at this point, I would also like to just briefly say that what I explained to you is also reflected in the recitals to the DMA. I quoted here recitals 32 to 33. which explain what is contestability, what is fairness, but they also say, which is important, that contestability and fairness are intertwined, because if you have no alternatives as a user of a platform, obviously, then, well, apparently the market is not that contestable anymore, right? Otherwise, alternatives might be able to develop. Then the other way around, the same argument works. So that is second question. Then the third question. This is a question reaching beyond the law and concerning more also policy aspects. If we don't really get along well with enforcing competition law, with effectively regulating these digital platform operators, digital ecosystem operators anyway, so why do we actually allow them to continue to operate independently? Why don't we just nationalize them? Well, this is a difficult question. Obviously, from a market-friendly perspective, you always try to avoid nationalization. And here we have an additional factor to consider, that is that also if you nationalize these digital ecosystems, you will still obviously need to operate them, right? And then conflicts of interests may arise because the state is then not just owning these ecosystems, but it has also to supervise them. And it could, for example, use that power of supervision to manipulate, for example, the content provided within social networks or via search engines to be, let's put it that way, politically more correct, right? Or it could, on the other hand, fail in its supervision because it says, well, actually, I want to pursue industrial policy aims with these structures, so that they should conquer basically the economy for me, but that obviously would also lead to deficient supervision. Now, still, and that is basically why not nationalizing is actually perhaps also something controversial in the long run. We need to consider at which cost, basically, we keep up with market freedom, and that is potentially overregulation. Here on this slide, I just listed the main statutes we have now in Europe that apply to those ecosystem operators. And there you see that even for individual categories, you may make subcategories, right? And what is it all about? I will not go into the details, but we have now special regulation for operating platforms. The DMA addresses digital ecosystems, but its focus is basically on the core platforms. Then we have other regulations on databases and so on used by platforms. We have regulation on the commercial platform users, their legal position, focusing on transparency and protection of market entry and so on. We have rules on the protection of end users, which sometimes have a broader reach and reach beyond platform markets. But also, for example, can build on AI, which is used in the digital world and is another factor where end users can be manipulated. Then we have a liability, a new regime of liability for platforms, for the content that you can access via the platforms. Think of pirate copies, but also counterfeit products or manipulating or hate speech. So there we are in the realm of the Digital Service Act, Copyright Directive, Euromedia Freedom Act that has been proposed. Then we have new regulation, which is expanding very rapidly, just regarding data. And there we've proceeded from the general data protection regulation, but that is basically on privacy interests. Now we have also new regulation concerning the sharing and of data and access to data, including the Digital Governance Act, which is on public data. So here we also see that this new regulation spans much broader and is going beyond platform regulation. And obviously we have ICT security, information communication technology security regulation, which can also play an important role in the platform world. Think of, for example, identification services or financial services being offered via platforms. And if we consider all this regulation, obviously someone will have to pay the cost for it. And whereas the European legislature is very efficient in drafting up regulation, I am not sure whether everyone is aware already how high the costs will be in the end for consumers. Okay, so with this as basically the general framework on the objectives of the DMA and its interplay with other statutes, let's focus a bit on specifically the DMA and data-related EU legislation. As I said, here the development is particularly fast, and that's why I wanted to have a short focus on it. And as I said, we need to distinguish two types of regulation. The GDPR, the General Data Protection Regulation, is the most prominent symbol basically of the first type of regulation, but the DSA concerning, for example, hate speech and data algorithms favoring hate speech basically on platforms like Twitter or social networks, that is part of the same concepts basically. And here we talk about the use of data to express something. Yeah, it's and that is basically an expression of fundamental rights. So whenever you you meddle with that, you manipulate these expressions of something, then you meddle with fundamental rights. And there is a need certainly for regulation to protect the emissionaries of the data against misuse. However, data is more. Data also is an economic resource for others. That's basically what the digital ecosystems build their business models on. Data is an input product. It is representing information, informative value, and this value is an economic value. So there also, when you then take the data, the question is not about protecting fundamental rights. It is about who on balance may own the benefits that come out of the use of these data. And that is basically in the focus of the new regulation. We're seeing now in particularly the DMA, but also the proposed new Data Act. So, and here we already get to another question, because indeed one representative in the audience asked whether the high costs of data collection may hinder small businesses' competitive ability, and basically following on this finding said, well, actually, there may be a question on how we balance privacy protection and market competition. And if we go briefly back, that's exactly those two circles you see here, right? One circle is on data as an economic resource, so that is market competition. The other one is on data to express something that is privacy protection. So what is the answer to the question? Well, I want to provide an answer based on the concepts used now by EU legislation. And there, the general principle is first that all data can be considered to be an economic asset. And then, if it is an economic asset, there is obviously no obligation to share data. However, you can share it, but it's the freedom of contract that governs the sharing of data and data access. Limitations can be imposed under the law. In competition law, we all know the essential facilities doctrine. However, the essential facilities doctrine can be complemented by regulation. That being said, it gets more complicated, where you have not just the interests of the two parties involved, so the party that is looking for access to data, but also the party that controls the data. You may have a separate data owner. You may have a third party that has a legitimate interest in the data. That can be, for example, a consumer, if the data of the consumer is stored on a company server, for example, or it can also be another company which may have business secrets in certain data. And so these third-party rights may frustrate access to the data. That is the general principle. So how do we then ensure that basically these principles and the regulation building on these principles don't put up harm, particularly for small business entities? Because obviously we know that there may still be ways to get to the data, and that it's the big players that know best how to use the routes to get to those data, and channels to those data, whereas smaller players may find it difficult or impossible to use the same the same options. Now, here the regulation reacts in interesting ways. First way is regulation is asymmetrical. So regarding data access, the Digital Markets Act imposes specific access obligations on gatekeepers, whereas the proposed new Data Act will limit data access by gatekeepers. Then an interesting different factor is that those general principles remain more or less untouched up to now. So even the Data Act, which is specifically on data access and data sharing, only contains limited new access obligations, and that is for smart device manufacturers. My personal understanding is that it's limited to smart devices because there you may have an interest as a data collecting company to keep on innovating, even if you are obliged to share your data. Whereas otherwise, if we don't have a smart device, but for example, a company where the core business is resting on the collection of data, in these cases, it's more dangerous to depart from the essential facility doctrine. Why? Well, if you are forced by regulation to give access to your data, obviously then you lose incentives to invest in collecting and analyzing the data, right? For smart devices, there may be still a core interest more in the device and not so much in the data. So there it may be somewhat different, but we'll have to see. Yes, and the Data Act, in addition to these rules, also then includes rules to specifically facilitate the data sharing for the benefit of micro as well as small and medium enterprises, particularly by protecting their legal rights under standard terms. we'll have to see whether that is going to be sufficient, obviously, because it's going to be another big chunk of legislation, but it does not seem to reach very far. Okay, next point. So we leave now the more general discussion on objectives and purposes of the law and go into the regulation of the DMA as such, starting with the norm addressees. So if you read the Digital Markets Act along my presentation today, then you'll know we have now covered Articles 1 and 2, and are now going to Article 3. So here another question was presented, and that relates to the well-known concept of an undertaking in competition law. And the question is basically how much broader will be the category of norm addressees in the DMA, and will we have some tensions in the future with this departure from potential departure from traditional competition law. And as you know, and this is also being reflected in the question, the term undertaking already was developed in European law to reflect on the fact that undertakings are market players. And so also when you consider what is dominance, for example, you ask yourself, well, what is market activity that is able to independently fashion the market on its own, basically. So if we start meddling with these concepts, obviously we may lose the connection to the market. And indeed, this was an important question in the legislative process, where originally the European Commission proposed to have indeed pure regulation and to clearly disconnect the DMA from existing competition law by also avoiding the use of the term undertaking. Now, Article 3, Section 1 of the DMA in the final version proceeds differently. It proceeds still from the term undertaking as the norm addressee. However, it is the undertaking that has been designated as gatekeeper. So we take the undertaking as the basis and then look whether additional aspects allow us to designate these undertakings as gatekeepers. So the term undertaking is also still defined in the DMA for the purposes of the DMA. However, such legal definitions are nothing unheard of. We have the same concept, for example, in the EU merger regulation. So with this, the DMA follows existing concepts. Yeah, the last point here is again what I said already. The draft DMA had taken a different approach. But now the question is obviously, how do we designate undertakings as gatekeepers, right? This goes beyond the question. So for this, I will now make a general comment here. Articles 3 and 5, how do they work? How do they operate? Well, we have here a multi-layered system that at the same time tries to facilitate enforcement and to be accurate in limiting the coverage to what we really want to regulate with the DMA. But as I said before, it's a form-based approach. So it is difficult to read into the law what actually the legislature had in mind. I already explained to you what the legislature had in mind. Now it's more on how the law actually looks like. So why it is difficult to read the law. The DMA provides for a designation of gatekeepers based on qualitative criteria and quantitative presumption. The qualitative criteria are in a general fashion set out in Article 3, Section 1, but they are the DMA is structured in a way that you usually don't need to make an individual assessment based on those qualitative criteria. Instead, you immediately jump to Section 2 of Article 3, where you find quantitative presumptions based on turnover and similar factors, which relieves the Commission then of a burden of the burden of proof with regard to the question of norm adjacency. And keep in mind, in traditional competition law, the first question would be for those gatekeeper structures usually would be, is this a dominant undertaking? And there can be obviously huge controversy about whether an undertaking has a dominant position on the relevant market. So this designation system is to neutralize this problem, this challenge. The designation has to take place in short deadlines. Here it is interesting that the Commission is not really bound by those deadlines. You can read this into the law. I'm quite sure this will be quite controversial, but you can read this into the law, even though the law provides for short deadlines. And you can do so because of Article 4, which allows the Commission to review the designations or non-designations anytime. So basically, no limitation for the Commission. If the presumption is rebutted or a counterproof is presented by the gatekeeper, then it is possible for the Commission to conduct a market investigation, and then only if this market investigation proves that the potential gatekeeper is something different and not a gatekeeper, then the company is being relieved. But otherwise, it will be submitted to the regulation, still submitted to the regulation. There is in addition an anti-circumvention rule for the splitting up of gatekeeper services to avoid being captured by those quantitative thresholds. And it is also possible for the Commission, even if all these factors now speak against designating a company as gatekeepers, to still designate the company based on an individual assessment, again based on the market investigation. Here it is also possible for the Commission to even designate companies as so-called prospective gatekeepers, but Article 17 then allows only for limited obligations to be imposed on those gatekeepers. A strange provision. I don't really know why they selected the specific categories of obligations that can be imposed on this basis, but yeah, this is something still of interest, obviously, and we'll have to see how it operates in practice. So you can have an individual assessment. However, that means that here we leave the quantitative approach. Here we have qualitative assessments and therefore very fact-intensive assessments to be made. And as I said before, even if you have then a first decision, reassessment can take place at a later stage, basically any time. So we have a very stringent set of regulations for the designation of gate. So this one, yeah. Okay, so that was the norm adjacencies. Let's proceed to the obligations applying to gatekeepers. And here we have in particular the conduct obligations now contained in Articles 5 to 7 of the DMA. Article 5 includes or contains fixed obligations based on existing decision practice, mainly based on existing decision practice. Here the idea is that we more or less know that this is conduct that we don't like, right? And Also, we know that based on the investigations that have been concluded so far, that it is very difficult to make an efficiency defense, towards an efficiency defense. Here, probably these categories came least as a surprise. However, they also caused controversies because it was said, well, and I must include myself on this point, well, this is basically competition law in disguise, right? It is nothing new, so why do we double what is prohibited under competition law anyway? However, from what I gather from the discussions we have had since the Commission published its proposal, here the idea behind including such a provision is not just, facilitate enforcement by saying, well, this might also be all covered by Article 102, but it's a general statute and no one knows how to apply it in the individual case. So basically, please stick to implementing the Digital Markets Act. There is another factor that is interesting perhaps, and that is that competition authorities tend to assume, if I understand correctly, that gatekeepers will understand that these are practices that will not be favored in the future, and so that they should, redesign their business model to move away from these practices. So here the DMA clearly has a filtering function regarding certain business approaches. Then we have Article 6, which contains also fixed obligations, which are intended to enable multi-homing or the switching of users. It includes interoperability obligations, but those are vertical interoperability obligations. So it's, for example, the supply of an API to then build on this API interoperable services. Also, Article 6 includes service or data access obligations that overlaps with the preceding categories also to some extent. And it is still, well, no, this is actually not, the last point is actually not right, sorry. This should be, it is like the Data Act, in the end it is asymmetrical. What I meant here, let me explain, because I deliberately put the term here. The regulation overall is asymmetrical. However, this provision individually considered may be considered symmetrical because it applies to all gatekeepers the same way. But we need to, and that is more important, we need to take into account that the overall regulation now is clearly putting gatekeepers under more obligations than others. So overall, we have an asymmetrical regulation. And you may wonder basically why I put here always the term fixed in regulation. I will come back to that when we address Article 8. There was also a question on Article 8. That's a particularly interesting provision of the DMA. So please stay with us on that. Article 7 then was also introduced in the process of the legislative proceeding. That's a new provision that was not contained in the original proposal by the European Commission. Here it's about horizontal interoperability between competing communication services. However, the economic rationale behind this provision is somewhat unclear. Why? Well, as lawyers, maybe, at least when I first read it, I thought, well, this is innocuous. It makes sense that we want to have interoperability between, let's say, Facebook and WhatsApp, sorry, and Telegram or Signal or other services because that's convenient. However, think of it, once there is interoperability, would you then still be interested to switch services? Maybe not, right? So, but maybe for the purpose of enhancing competition, it's better if you use a switch, right? So difficult question, basically. However, the European Parliament is still got its way here, and we'll see how this provision then works in practice. So these are the three main, conduct provisions on conduct obligations. We have obviously then some strict regulation, and there the risk is that the new statute will maybe outdated quickly because business develops. However, Article 12 allows the Commission to some extent to also supplement existing obligations. It may also conduct market investigations under Article 19 for that purpose. However, the removal of obligations is only possible based on a market investigation. Here, the background of this rather stringent system is basically a constitutional thinking. You know, we would say that the obligations applying to gatekeepers are so important from a legal perspective that this is something that should be decided on by legislature and not by a mere agency. However, obviously, the legislative process may take too long. That's why there is a way for at least some delegated legislation. So next questions, and here comes a row of questions, if I am not mistaken, on the obligations. So first question, very, very good question. To what extent actually does the DMA prohibit conduct that is not prohibited under Article 101 or 102 TFEU? So the basic cartel and abuse prohibition of EU law. Well, actually, the DMA goes beyond established competition law, and that holds even for Article 5, where I said that it is based on concluded as well as pending competition law investigations. Now, obviously, to the extent that it is based on pending competition law investigations, there is a certain risk that the agencies conducting those investigations may be mistaken. So basically, also the DMA might prohibit something that is not prohibited under competition law. Well, and we have already had one example where it is now unclear what competition law actually says, and that is the investigation against Amazon on data and on its buy box. Because this investigation was now closed against commitments, but the DMA still includes rules that specifically regulate the relevant conduct. Still pending is the Apple App Store investigations, but also here the DMA already includes stringent conduct obligations. So in some points, also individual provisions included in the DMA deliberately were phrased in a way that goes beyond what was decided already in competition law. For example, or most prominently for narrow price parity clauses, where the emerging consensus in Europe seems to be that we allow for narrow price parity clauses and only prohibit wide price parity clauses. The DMA makes no distinction. For gatekeepers, however, that may also make sense if you are in favor of such legislation, because their business has a farther-reaching impact on the market than the business of other platform operators using price parity clauses. Some provisions also don't relate to specific case law, even in Article 5, for example, or most prominently Article 5, Section 6, which prohibits gatekeepers to make it difficult to report gatekeeper violations to the authorities. And still, we need to consider as the most important point that even to the extent that this is based on existing competition practice and the agency procedure has ended in some instances, there is no underlying case where you have a final appeals decision. I'm not sure whether actually this holds completely for the prime parity cases, but for all, at least the commission cases, all in commission decisions are still pending before the European courts. So Article 5 clearly is already going a step ahead in that regard. Article 6, as I said, is about allowing users to switch services, basically, so or to multi-home, and therefore includes provisions that either facilitate that switching or multi-home, or that allow others to come in with alternative products. Most of these provisions are not based on specific case law. Sometimes, however, you can find case law that is supporting such provisions. And I listed some here regarding the Amazon marketplace that was actually an investigation relevant particularly for Article 6. Article 7 was, as I said, introduced only by Parliament. That is one of the instances where the EU legislature took some legislative liberty, basically, and used its legislative discretion. This is not based on existing competition pressure. So, looking a bit more narrowly, the question was posed to me: what was the reason why the pre-installation of gatekeepers' mobile apps was not prohibited completely? Well, the DMA includes certain provisions on pre-installation, but they only impose an obligation to allow users to uninstall something that has been pre-installed by the gatekeeper. And this is what this question is referring to. Those provisions can be found in Article 6. The impact assessment accompanying the DMA proposal to the DMA provides an explanation why the European Commission did not propose anything more far-reaching. And that was for proportionality reasons, so legal reasons behind it. From an economic perspective, my understanding is that many economists subscribing to the issue of digital ecosystems, that is obviously also an important caveat, would rather have gone for a complete ban on pre-installations, because they say, well, if the market is damaged heavily by the existing of digital ecosystems, so the market structure is not that lively anymore, then pre-installation is particularly dangerous. However, from a legal perspective, certain arguments can also obviously be raised in the direction of proportionality. However, and here we get again to one of those points where it is really difficult to understand basically how the DMA is going to work in practice, because it is silent and it does not address the important points, the interesting points. Here, the interesting point is that you have to keep in mind that all individual obligations of the DMA apply in parallel. So even if the DMA does not ban pre-installation completely, keep in mind that very often pre-installation comes along with tying or other measures to hinder switching of users. But there are separate obligations concerning these practices, and these kick in parallel to the pre-installation rule. So, yeah, we'll have to see how this is going to be implemented in practice. Next point, interoperability under Article 7. There was a question, what does this actually mean? Good question also, obviously, because it is a political measure, right? However, you can also indeed understand the term in various ways, and the most limited way would be, well, actually, users should be just granted an option to port their data. So some fixed type of interoperability that can be ensured by that, but no dynamic thing where you can say just as a user, well, I want to change services, switch to another service, and then I must be able to do that however that works, basically, right? So even without data porting. Now, first, a general remark once more. To be clear, Article 7 encloses just horizontal interoperability for communication services and must be distinguished from Article 6 on vertical interoperability. However, Article 6 also includes a provision on data portability. So this type of rule that can be found now in Article 7 must go beyond Article 6 to some extent. Now, fortunately, the final version of the provision includes basically also the final version of the DMA includes also a definition of what is to be interoperability. That definition cannot be found in Article 7, but in Article 2, which includes all the definitions, and there it says, well, interoperability has to be ensured by providing technical interfaces or similar solutions necessary for the switching of services. And that would go beyond data portability. So I have discussed with you now the individual conduct obligations as well as including them, the designation of gatekeepers, and these are obviously all the provisions that someone new to the DMA basically would be most interested in, right? However, the most important provision of the DMA, or the provision where you see the provisions, where you see that the DMA is clearly something new in EU law and as EU regulation, is or are Article 8 and Article 8 in conjunction with Article 13. Why is that? Well, this is difficult to read for the audience here. I hope it's easier for you on the screens at home. Article 8 is a provision that sits somewhat between regulating the burden of proof and substance. It contains an additional obligation to ensure and demonstrate compliance, even though obviously you can read such an obligation directly into Articles 5 to 7. In particular, as Article 5, Section 1 and Article 6, Section 1 now explicitly also say that the gatekeeper is obliged to abide by the following rules. Now, Article 8, still also includes that express provision that the gatekeeper has to ensure and demonstrate compliance. Demonstrate means the gatekeeper also has to prove it. Compliance must be effective, but, and that is basically where the law becomes interesting because it starts to go beyond Articles 5 to 7. Compliance must be effective regarding the objectives of the DMA, not the objectives of any individual provision of the DMA. So even though you can read obviously that compliance obligation also into Article 5, for example, but you still may find it a bit harder to say, well, it's still possible, but it's a bit harder to say, well, actually, also the compliance must be ensured with regard to certain objectives of the DMA. There may be cases where, for example, you think, well, usually the two should be in line, right? Article 1, which sets the general objectives, and Article 5, 6, 7, which does say, well, certain conduct rules, but usually that should be in line. However, when you are in a case scenario, practical case scenario, it is not inconceivable that the norm agency will raise an argument and say, well, actually, I consider my practice to be in line with Article 5, for example, whereas the agency says, well, actually, yeah, by the letter, it is true, but still it's not meeting the objectives of Article 1. What do you do then? Well, here, this additional obligation can provide arguments to the enforcer. Then Article 8 also includes a provision on so-called specification of gatekeeper measures. That specification can take place either upon request, that holds for applies for Articles 6 and 7, or also to Article 5 in cases of circumvention. And then, somewhat in relation to Article 8, we have to consider that it's possible to have a regulatory dialogue. That is not mentioned expressly in Article 8 anymore. It used to be mentioned in the previous version, Article 7 of the EU draft proposal, and I will get to that. Regarding the specification, I will also have to say something. Here we come back to what I said before, that Articles 5 to 7 include fixed obligations. So a big question for a long time already when the proposal was around was what actually is specification meant for. However, we also got a question here from the audience regarding specification, so I want to go into the details in a minute anyway. Here, at this point, I only want to make clear that, I only want to explain why Article 8 actually does not contain any sanctioning rules for non-compliance. That is quite interesting. If you take everything I have said so far, then obviously you would expect severe sanctions for non-compliance with Article 8. However, interestingly, there is no sanctioning regime for the entire set of obligations under Article 8. There are only very limited possibilities to sanction. Why is that? Well, if you don't comply with Article 8, you either have non-compliance with Articles 5 to 7, then the sanctioning regime for those provisions applies, or, and that is where the other important provision comes in that I mentioned, becomes relevant, or you have circumvention. And then you would take Article 8 in conjunction with Article 13, and then a different sanctioning regime would apply. So this is the structure of ensuring compliance. Then let's have a short look also at Article 13. This is in itself a very new type of rule for EU law. Anti-circumvention rules have existed, but were very limited so far. Now we have a very prominent example of such a rule here, and it's actually a substantive rule. It is not a procedural rule, but it includes additional obligations regarding the conduct obligations. It is prohibited to undermine these obligations through another conduct that has the same effects. And there are special obligations also regarding user consent included in Article 13, and a prohibition to inhibit users to make use of their rights or to sanction them for using their rights. And Article 13 also would, for example, prohibit the use of dark patterns, even though Articles 5 to 7 do not address dark patterns specifically. However, just as a side note, Articles 5 to 13, which focus more on substance, are not the only provisions that concern the insurance of compliance. In addition, we have Article 28 as an organizational tool to ensure compliance, because the gatekeeper has to implement a so-called compliance function in its structure. So there has to be a separate department within the gatekeeper to make sure that its business practices align with the DMA. And there has to be also a sanctioning procedure. Also there we have rules in articles 26 to 27 and 29. I will shortly also address Article 26 once more a bit later. So now to the very relevant question that questions that were asked with regard to this compliance regime. Here the question was asked basically, okay, so the DMA, at least the draft DMA, included provisions on this regulatory dialogue. We know also that under the final DMA, this concept is not dead. What does it mean? Does it compromise perhaps even enforcement? Because if you have this dialogue, then that may mean that the obligations are always under a certain precondition. Then that is that the gatekeeper does not convince the Commission to have it otherwise in another way. Well, there are a couple of things to be said about this. The regulatory dialogue is very complex, regulated now in a very complex fashion. And again, the most important complexity follows from the DMA itself being silent. The DMA does not mention the regulatory dialogue in its provisions anymore. It only refers to it in one recital, which says that the EC should, the European Commission should specify implementing measures following a dialogue with the gatekeeper. This is not as far-reaching as the draft proposal had it. Before we get to the problematic parts of the dialogue, we certainly should note that it comes along with certain benefits. It can be useful to achieve an appropriate design of gatekeeper measures. And from a procedural standpoint, it may also allow the Commission to withdraw enforcement or to not act very hard in enforcement terms whenever it considers that there are very important efficiencies that could be destroyed through the enforcement. I briefly have to drink something because my voice is failing. Thank you. So we have certain arguments in favor of the dialogue, but we also have to make certain caveats reflected also in the question presented. Here, the important point to make is that what I say is just for now an interpretation of the law, and we have to see really what is being done, going to be done in practice. However, my interpretation of the law is that actually the DMA is more stringent than it seems, even if you recognize the possibility of a regulatory dialogue. Because the obligations as such, as I said, are fixed. What can only be specified under Article 8, that is something I might have also made more clear before. What only can be specified in Article 6, under Article 8, is the measures the gatekeeper takes to adapt its conduct to the obligations. So the obligations as such are fixed, but what the gatekeeper does to adapt its conduct, that may be somewhat specified. But that doesn't mean, obviously, that it has any limiting character for the obligation as such. And here the dialogue can also come into play, because the dialogue, it may be there for the gatekeeper to explain why it does not take certain measures. And then again, the question is not what is the realm of the ambit of the obligations, but rather should the Commission immediately start sanctioning the gatekeeper, or should it, just wait, right? That is how I understand the regulatory dialogue. And if we understand it that way, then this risk of the obligations being compromised is not that significant anymore. But as I said, this is just an interpretation. It might also be interpreted differently, and also obviously there is still a risk that in practice, the DMA might fail to some extent because the Commission does not enforce it the right way. On the other hand, however, and that's something we'll cover also, the DMA is not only enforced by the Commission, and again, here you have an area where the DMA is silent. The DMA may also be enforced privately. And so basically, even to the extent that specifications and regulatory dialogues don't limit the measures taken by gatekeepers, additional obligations might be imposed by courts. We'll also have to see whether this is going to happen. But before we get to those areas of procedure and enforcement, first let's end up with the obligations. We have had now the conduct obligations and the compliance obligations in Article 8 and 13. There are still two more obligations to mention. There is an obligation to notify acquisitions in Article 14, and an obligation regarding the accountability regarding consumer profiling measures in Article 15. I will not go into the details on these obligations, but just wanted to briefly mention them. Regarding the obligation to notify concentration, we also had a question here, and that is basically whether which impact the rules of the DMA will have on acquisitions, and whether we can even have some prohibitions of so-called killer acquisitions on the basis of the new regulation. Now, Article 14 DMA only includes an information obligation for the gatekeeper. So it really does not go as far regarding killer acquisitions as many had wished for, many had expected. There was also controversy on this provision during the trilogue of the EU institutions responsible for the legislation of the DMA. However, the institutions finally decided not to go any further because prohibition to acquire any potential startup or whatever. So any company, even not meeting this, the lowest quantitative merger control thresholds, was considered to be very far-reaching and therefore abandoned. However, the final DMA includes in the rules of market investigation also a provision that empowers the Commission to prohibit the gatekeeper from making acquisitions, at least temporarily, if there is so-called systematic non-compliance, so 3 times non-compliance with gatekeeper obligations. Whether this provision will have any impact in practice also remains to be seen. My personal view is that it is highly doubtful. Why? Well, as I said, this rule was included in a provision on market investigations, and the purpose of that rule is, in general, to ensure compliance with the conduct obligations of the gatekeepers. However, that means, just legally speaking, that all measures imposed will have to meet proportionality standards. And those proportionality standards will have to be aligned with the objective of ensuring conduct of compliant conduct. However, the conduct obligations contained in Articles 5 to 7 don't necessitate any acquisitions, right? And on the other hand, also, it is difficult to see how an acquisition may change anything regarding the compliance with those conduct obligations. So in my view, gatekeepers will have strong arguments frequently to say, well, if this rule is being used, this is not suitable to ensure conduct, it is not proportionate. Therefore, I think they can challenge any order based on this Article 18. And so this rule, in my view, may not have a strong impact in practice. However, even if killer acquisitions are not being handled comprehensively under the DMA, it is possible, because we are in the EU, we have a two-tiered competition law system, and merger control is part of competition law. We can have still national rules that kick in and provide for more stringent control. As an example, I here included some information on the German rules, where we have also an obligation to notify concentrations, even without a prohibition, specific prohibition competence. And that was recently introduced in the 10th Amendment, I think, 9th or 10th Amendment, 10th Amendment to the Competition Act, and is now being broadened again, and will also specifically allow the FCO to ask for the notification of those transactions that take place in an environment where there is a risk, threat of an impediment to effective competition. There's also a new provision that allows the Federal Cartel Office, the German Competition Authority, to proactively, preemptively break up companies where there is a threat of significant impediments to effective competition. So something similar to what we know from US law, basically, I would say, even though the example for this regulation was found in the United Kingdom, which also allows the CMA, the British competition authority, to open up markets with structural measures based on a market investigation. So this was taken over here for German law, and in conjunction, these two provisions might also prevent the use of killer acquisitions to further broaden ecosystems, additional ecosystems. Sang-Yoon Lee, who's present in the audience today, told me that Hungary introduced also intervention rights. I found that also in the meantime an interesting new statute. So also other member states are interested in legislating in this area. France is likely to do the same, but I'm not aware of the legislative procedure to be completed there. So regarding killer acquisition, we'll have to wait and see. Perhaps if many member states legislate in that area, also the Commission may try to broaden the ambit of the DMA once more. So this was all I had to say on the obligations. Thank you very much for your attention so far. Please bear with me for a couple of minutes still, because I also wanted to address the enforcement. And here we also had a couple of questions regarding enforcement. One important question also frequently raised in the EU is who is actually going to be responsible for enforcing the DMA in practice, and also considering that it is the EU Commission that is exclusively competent to enforce the DMA. Well, within the European Commission, different teams will very likely be responsible for competition law on the one hand and DMA on the other hand in the future. And within those teams for the DMA, you will also have a collaboration of different units of the European Commission. And those units will come from DG Com and so the Directorate General for Competition, and DG Connect, the Directorate General for Information Communication Services. That is at least my information so far. And I listed here the relevant departments. And these will have to cooperate then with, but the way they cooperate will obviously have an important influence on whether this the DMA will be enforced more competition in a competition way or more in a regulatory way. But it's well possible that it will indeed be the regulatory way in the end. Next question: do national authorities have a say actually in DMA enforcement? From what I've said so far, you would say, conclude no, because I said the Commission is the sole enforcer, but we are in the EU, and there everything is more complicated. And so the right answer is actually yes. How is that possible? Well, while the European Commission will be the sole enforcer of the DMA obligations and also solely responsible for designating gatekeepers, there may be a need to decide basically whether the DMA is applicable at all, right? Also, when you see some kind of anti-competitive behavior, potentially anti-competitive behavior, where you wonder, well, this might be a gatekeeper that is acting here, or you know even that it is a gatekeeper, and you may think, well, actually, this is not just competition, or it may also run counter to the DMA. For this reason, it was hugely controversial in the legislative process to limit enforcement of the DMA to the Commission and not basically align the enforcement completely with competition law, where you have this two-tiered system and also national agencies are involved. The solution ultimately found was that national legislature may empower national agencies to conduct preliminary investigations, and then a complicated rule set applies of interlinked rules where national legislation, in addition to the DMA, provide who actually has to do what. But in the end, it still remains the Commission that enforces the obligations of the DMA, and it is only the Commission that does so. The Commission must be informed of any measures that national agencies take, and here this also kicks in at a very early stage. Why is it actually that now we have had this need of so comprehensive regulation also at DMA level on these matters? Well, it's not just that the Commission does not want its sole responsibility to be compromised, but it's also to avoid market fragmentation, right? Remember that the whole DMA is about reducing market fragmentation. However, for the undertakings concerned, the potential or the real addressees of the DMA, and also for the public, it is difficult to distinguish actually who has competences to do what. And so basically there is a great risk that the public impression will arise that it's actually a shared competence. And so that if, for example, the German Federal Cartel Office, I don't know why it comes up just in context, but if, let's say, the Federal Cartel Office were to say, well, I know what's right, then it may say something different from the Commission. And then for the public, the question would be, well, who is actually right, right? And that was particularly what was to be avoided with the DMA. So therefore, complicated rules are necessary regarding the interplay of agencies. In addition, however, also more complexity comes in through the fact that obviously the DMA is a new statute in a legislative environment where there are also other statutes already existing, and also this relationship had to be regulated. The DMA specifically says in Article 1 that regulatory obligations of gatekeepers remain in place beside the DMA, and also competition law can apply in addition to the DMA. This includes also the notorious Section 19A of the German Competition Act, which I mentioned here also explicitly to show where this statute will retain its scope of application to the extent that the legislative conduct obligations in Articles 5 to 7 kick in practice. Section 19A will cease to be effective, will be superseded by the DMA, but obviously there is still some room for it where, for example, a company has not been designated as a gatekeeper so far, where its platform services are considered to be core platform services subject to Article 3 of the DMA, or where the obligations possible under Section 19A of the German Competition Act go beyond individual provisions of the DMA. In addition, also we have now this new market investigation tool that is in the proposed 11th amendment to the German Competition Act. That I should have said before is a provision that is likely to come, but it's not enforced yet. However, that would also be applicable besides the DMA. Another question still to be covered is what guarantees are there for private parties that have an interest in conduct covered by the DMA, particularly private parties, for example, that want to have access to data under the DMA, or that want to prevent the gatekeepers from engaging in certain conduct. And as I said, here we are again in an area where the DMA is silent. It says something about public enforcement, but it does not say much about private parties. Regarding public enforcement, at least, it says that private parties are recognized as information bearers and may complain to the Commission or to national competition authorities regarding infringements of the DMA. In addition, there will be the possibility, there will be a high-level group of authorities, and also the member states will be there to complain to the Commission whenever they see that private parties are being harmed by gatekeepers, and this can be used also then by the Commission in its public enforcement to the benefit of private parties. However, the open question then remains, that's an important question, is private enforcement possible? Under the Commission proposal for the DMA, this was really unclear and very controversial. Even though a majority of scholars said, well, actually, we cannot prevent private parties from making their rights known in court and enforcing their rights in court. The final version of the DMA underlines that this was also what the commission, how the commission saw things, because it includes at least some references to private enforcement. For example, it contains a provision on the cooperation of courts. It also, however, includes a new provision on class actions in Article 42. So now the question is not anymore whether private enforcement is possible. It's more the question, how can we actually implement this private enforcement in parallel to commission public enforcement. Here, the Commission has apparently in mind that this works a bit like in competition law, where we also have provisions on the cooperation between the Commission and the courts, particularly, for example, for leniency and the use of leniency documents in courts. There's a broad rule set on that. This seems to work quite effectively, actually, also the flow of information between the Commission and the courts. But we'll have to see how it works for the DMA. As I said before, the relevance of the new provision will probably be the relevance of the DMA in private enforcement will be particularly likely for data access and interim measures. It's not that likely, in my view, at least personal view, that we see lots of damage actions simply because we need to consider that gatekeepers are acting in an environment where it's very difficult for others to come into the market, and that won't change, right? The DMA does not break up the gatekeepers. It only imposes conduct obligations in that existing market structure. But if that's the case, then it's also difficult to base the damage actions on action on the DMA. I would say it's more likely then that companies will still continue to rely on competition law and say, well, this had a damaging impact, basically not just on the market, but also on me and negative market effects. But we'll have to see. So with this, I come to the end of my presentation. I was at a bit slower than I expected. I still obviously hoped that it was not too much because we had lots of things to cover, and obviously it is not even Japanese legislation, which is certainly of more value to everyone here. But it still was an absolute pleasure to make this presentation to you, and I am very grateful that again of your interest in EU competition law. So thanks once more, and if you have any questions, I'm still available. I don't know how much time is left, but you can also contact me now at my new employer by email. Thank you very much. Should I say on the commentary also? Yes. Okay. Sure. Yes. Thank you very much, Okui-sensei, for bringing this up. One reason, basically, for giving today's presentation is that together with Professor Eckhard Bühren from the University of Göttingen, I'm at the moment commenting on the DMA. This was helpful as for such a commentary. It's necessary to make a very detailed analysis of the statute and all relevant enforcement and literature. And this helped to better understand how the DMA functions. It is one of the most prominent commentaries that is available on competition law, where we add now a section on the DMA. And Professor Bühren and me, we cover articles 3 to 13. So the provisions that also were most prominent in today's discussion. Even though we only can make a very initial assessment, I also obviously here said very repeatedly that I can just give my personal views. We still could get a bit deeper into the matter than some commentators, just because we had to do this research for this work, for this publication. Publication will take place in the first half of 2023, but it is not clear yet when exactly. We expect now around Easter. Yeah, another question, thank you, is in which language? So far, it's being planned to make a German, well, the commentary is just German. However, it is planned to make then also an additional publication where we take out just the DMA and publish that, maybe in a reformatted way, because German commentaries are not an international standard, to make that available also to an international audience. When this is going to happen is, however, still unclear. I mean, we need to consider that the overall commentary of the DMA is will be quite a large publication. Just regarding the volume, it's around 450 pages of commentary in the first edition, and yeah, the translation will take a while.